It's your boy. You know what time it is. Shout out to True Freeman.
Hall DUI, expired driver's license.
Good morning, Judge. Judge, I need to say how I'm appearing today, sir.
Hold on, wait, let me finish. Hold on. All right, hold on, Mr. Hall. Sir, you've been charged with DUI, exchanging a plate not assigned, license suspended, failed to drive in a single lane. Just give me a moment, sir. Let me look at your driving record. Okay?
Sir, I haven't said for the court how I'm appearing today,
Well,
sir.
I'm not asking you yet. Just give me a moment, all right? I need to look at your record. Okay, I'm looking here. Failure to pay traffic tickets. Back 11. Open container out. Okay. All right, sir. Hold on. Does this gentleman, Mr. David Hall, does he have any criminal record?
Yes, Judge, and he also has pending felony DWLSs in front
Okay,
of
what's the pending felony DWLS?
you sign. Okay, there's a few.
I'll give you a moment to talk in just a moment, sir. Hold on, Mr. Hall.
The pending felony is 14016-582 CF10A.
Okay.
He also has pending misdemeanor DWLSs in front
What is
of
that? What are they?
Judge Evans. Case number 14053
Wait, 1-4 what?
909 TC30A.
TC30A. Okay. That's it?
And a criminal history.
Okay. Now, Mr. Hall, so would you wanted to say something.
Yes, may I speak, Judge?
Well, don't tell me about what happened or did not happen regarding the DUI, but if you want to tell me about something
I'd like to
else, go ahead.
state some things.
Go ahead.
I'd like to state some things for the record. Thank you, Judge. Judge John Hurley, I do accept your oath of office here today for the record, sir.
Thank you, sir.
Thank you.
Yes,
Does
sir.
this court take judicial notice of your oath, sir? With all due respect.
You see. I take judicial notice of my own oath. Yes, sir, I do.
Thank you. Thank you very much, sir. Sir, today I'm appearing as the agent and settler for David Hall.
Okay. Okay. Could you get Mr. Hall for me then, sir? Where is he?
I go by that name, sir. My name sounds exactly like the defendant's, and I'm here to settle that matter today.
So are you and David Hall one and the same person?
I'm not a person, I'm an individual. David Hall is a person. I am
David Hall, one and the same individual.
by the name David Hall, sir, and I'm here about that matter today.
Okay, so you go by the name David Hall. Okay, so this is what we're going to do. The person who goes by the name of David Hall is standing in front
I'm the individual. I am an individual, not a person.
You're not a
Yes,
person.
sir. David Hall is a person. I am a private individual. David Hall is a person under color of law, sir.
Okay, where's David Hall then? The person David Hall.
Exists on paper, sir. David Hall is a corporation. This action is under color of law, sir, and I do understand that. I am here in my real capacity as the private individual for that name, and I'm here about that matter.
You're the
and I'm happy to
you're
settle
the
it.
private individual, David Hall.
I'm the settler, sir.
You're the
I'm the
settler,
settler.
David Hall.
I'm the settler to David Hall, sir.
Are you the
I'm happy
private
to-
individual, David Hall?
Yes.
Good. Okay, we got that straight. We agree on that. Okay. Now, David
May I,
Hall,
sir?
David Hall, the private individual. I'm looking at your driving record right now. Multiple failures to pay traffic tickets for the individual, David Hall, not the person. But, sir, what I'm going to
Can
do...
you clarify, sir?
Go
Sir, I'm not sure I understand that, but I'm happy to settle this matter right now if somebody will make presentments. Nobody has made presentment, and I've asked numerous times, and for the
When
record,
you say presentment, what do you mean by presentment?
Presentment of the charging instrument for set-off and settlement, sir. I am the settler.
I just told you what it is. I told you what your I told you what the individual
Presentment,
David Hall did.
Judge.
Yes, sir.
I will require somebody to make me a presentment of the charging instrument on paper so that I may settle that matter. I'm here as settler, and I'm happy to settle this charge
We're not
right now.
We're not settling. Today's not the day to settle matters for these kind of charges. All right. We don't settle them today. All right.
May I say something else for the record, sir?
Go ahead, sir.
Thank you. I am secured party under a UCC filing at the Secretary of State 201-308-717-006.
Okay.
I am secured party to David Hall on the record and through a filing at the Secretary of State, sir. I appear here today as the settler, agent, not the person, but the individual. And I don't think I should have you understand the
So
difference
you're the
between a
settler,
person and an
you're the
individual.
agent, and you're the individual, but you're not the person. Is that correct?
Correct.
Got it.
Correct.
I'm going to write that down. Settler. This too. And I was a little uncertain, but it's all become very clear now. Now, okay, the settler, the agent, the individual, but he's not the person. Okay, so does the settler, the agent, the individual have any money in the bank?
Yes.
Okay, how much money does the settler, the agent, the individual have in the bank?
I'm not certain at this time, sir.
Okay.
Only that I will give an affirmative that there is money in a bank account.
Okay, and how long has the settler, the agent, and the individual lived in Broward County?
25 years, sir.
Okay, does the settler, agent, individual own any property in Broward County other than personal effects?
No, sir.
Okay, now, does the person own any property or have any money in the bank? If you know.
In conjunction with myself, sir. In conjunction with myself, we both have. Yes, I'm the agent for that account also.
Okay, got it. Okay, so now, here's what we're gonna do. The settler, the agent, the individual, and maybe even the person, David Hall, has been charged with DUI. A DUI while the settler, the agent, and even the person, David Hall, was out on bond on 2 cases, 1 felony and 1 misdemeanor, for license suspended. So the court believes that the settler, the agent, the individual, and even the person represents a danger to the community, because the settler, the agent, the individual, and even the person continues to drive without a valid driver's license, in fact, a suspended driver's license in the state of Florida. And so that being said, the court is going to...
May I make a correction, sir?
Go ahead, sir.
Yes, I'm traveling. You said that you used the term driving, and I was traveling, sir. Traveling.
Okay. All right. So the settler, the agent, the individual, or the person, David Hall, for traveling on a public highway or public road in the state of Florida, was allegedly doing so without a valid driver's license, and has done it several times in the past. So today...
This is alleged, sir?
Yes, sir, it is alleged.
Allegedly?
Yes, sir.
Thank you.
So today, the court's going to set the settler, the agent, the individual's bond, and even the person's bond today on count 4 at $10,000, because the settler, the agent, the individual, and the person has not stopped driving, even though the settler, the agent, the individual, and the person continues to drive without a driver's license. So that being said, count 1 is $500, count 4 is $10,000, and the court will revoke the bond for the settler, the agent, the individual, and even the person of David Hall on 14-016-582 CF10 and 14-05-3909 TC30A. Both cases will cause the settler, the agent, the individual, and even the person, David Hall, not to be able to be released from the Broward County Jail until further notice of the court. So,
May I post bond, sir?
well,
Is there any other?
are you asking me as the settler, the agent, the individual, or are you asking me as the person?
Sir, I'm asking as the individual appearing before you today about this matter.
Well, the
Do
individual,
I have?
the settler, the agent, the individual, or the person can post the bond. However, the settler, the agent, or the individual, David Hall, will not be released in any event because this court is revoking the bond on a felony case and a misdemeanor case on the settler, the agent, the individual, and the person, David Hall.
Where's my remedy, sir?
Well, whose remedy are you asking for? The settler, the agent, the individual, or the person?
I'm asking for the
Wait, who are you
opportunity.
speaking on behalf of right now?
Sir, I don't understand that question. I believe that you're trying to confuse me now.
No, I'm not.
I'm
no.
simply separating myself from the person. They are two different entities,
Right,
and I know
but
that.
the court is not viewing you as two different people. The court is viewing you as
Well,
one
why not,
entity
sir?
for the purpose of these cases.
Then what entity are you referring to me as?
I'm
Because
referring
you're referring to me as
the David Hall, who's the settler, the agent, the individual, and the person.
I'm not the person, sir.
Okay,
I am
you
not
see
the
person,
person.
David Hall. Tell him he's not leaving jail either. All right?
Sir, then may I ask what my remedy is? Can you provide me a remedy so that
The
I
remedy
may...
is you don't really have
I
a
will-
remedy where you could appeal it to the 4th District Court of Appeal.
How long am I going to be held, sir? I would
Until
like to
another
settle
judge
this matter.
tells you you can be released.
I would like to settle this matter, sir.
We're not going to settle it today.
Then I'm being denied for the record, I'm being denied my remedy.
What do you
For
think
the
your
record,
remedy
my
is?
remedy is being denied. For the record, I am the real individual, and this action is under color of law, and I don't understand this color of law action.
Okay. Well, have a nice day.
My name is Stephen. I'm here under common law jurisdiction, exercising my rights.
Let's get something straight. We're not here under common law, we're under here statutory provision. That's all I can hear is statutory.
Is this Admiralty law, sir?
This is not active.
What courtroom are we in? Is this a courtroom?
This is a hearing.
Are you a lawful judge? Are you a lawful judge?
Administrative hearing officer. Employed, contracted before 7. Stephen Johnson.
I am the authorized representative.
Are you an attorney? You're Stephen Johnson, and we're not having a hearing.
I'm the authorized representative.
There's no such a thing as an authorized representative. Either you're Mr. Johnson or you're not.
I'm not Mr. Johnson. I'm here as an authorized representative of the legal entity, Mr. Johnson.
You're an attorney.
I don't have to answer that question.
Yes, you do.
Am I obligated?
Unless you answer that question, I'm not conducting a hearing.
I'm here in honor, sir. Trying to stay in honor.
Either you're Mr. Johnson or you're not Mr. Johnson. If you're not Mr. Johnson,
I am the legal,
you can't be a legal representative
Yes,
of
I
Mr.
can.
Johnson.
I'm the authorized representative
The only representative we
of the
allow
legal entity, which was,
is a person, Mr. Johnson.
I am a living being. The Mr. Johnson is a corporation.
This is,
I'm not a corporation, sir. I'm a living being.
so is Mr. Johnson.
No, sir.
Well, since Mr. Johnson doesn't appear, I'm going to enter default.
No, I am here. I am here as an authorized representative and in honor of that legal entity. You can't. I'm here trying to resolve the matter, sir.
Sir,
Are you a lawful judge? You're not here to.
Don't interrupt him. He is a judge.
I'm sorry. I just to clarify.
let me
That's all.
start the interview. Good afternoon. My name is Richard McManus. I am an independent hearing officer who will conduct your hearing this afternoon. You're here today for hearing concerning alleged violations of Colorado Public Highway Authority law as it pertains to the E-470 Public Highway Authority. I want to explain what we're going to do this evening. First, you need to know that you may not record this hearing either by audio or video recording. Do you understand? You understand that?
Sir.
You're not to record either by audio or video this hearing. Do you understand that?
I have the right to.
You don't have any right to do anything about recording.
I have a constitutional right, do I not? Does the Constitution does not apply in this courtroom? Is that what you're saying?
Sir, just tell me you can't video record this thing. So if you have anything that's recording this hearing, turn it off at this point. Do you understand that?
I believe I'm exercising my rights, sir.
You don't have a right to record this hearing. Do you understand?
No, sir.
Second, you need to know that I have no authority to suspend or modify any proposed toll, fee, cost, or penalty. Do you understand that?
I'd like to exercise my right to remain silent.
This is not equivalent. You see, you do not have that.
I don't have any rights.
Right to be represented at this hearing by an attorney. You're Mr. Johnson. This is your right. You're not an attorney. You can't represent. You're recording this.
I'm sorry?
You're recording this.
No, I just have the right to exercise my rights. Do I not, sir?
You have all the rights that you have as a citizen of the United States.
If I was a citizen, I'm a natural person, not a citizen. That's a 14th Amendment created entity used. Are you familiar with Black's Law, sir? Are you here
I'm
on?
not familiar with all the laws, sir. If you are not Mr. Johnson, we're not going to have a hearing on this matter.
I'm the authorized representative of that.
You are not an authorized representative, sir. Unless you want to comply with the judge's conditions I set forth, we're not going to have it.
Well, I'm here in honor as the authorized representative of the legal entity, Stephen Eugene Johnson. There is no Mr. If you put Mr. in front of anything in accordance to Black's Law Dictionary, it is a corporation. Mr. Johnson, Stephen E. period Johnson is a corporation. Stephen Eugene Johnson in all capital letters is a corporation. Anything in all capital letters is a corporation. I'm just explaining the law, sir. I thought you knew it.
I reject that. I can explain the law to you.
Okay.
You're not a lawyer, so I don't accept what you said. Now, unless you admit to being Stephen D. Johnson, we're not having this.
I do not do such. I am the legal entity. My name is Stephen.
Fails to appear.
My name is Stephen of the Johnson family. I am not the corporation. I'm not going to enter myself into joinder. No, sir.
You can do whatever you want, but I'm going to enter a judgment against you, which can be enforced in the courts of the state of Colorado.
Well, I guess you're going to have to do that. Then I can get to the right courtroom.
The court will render a default judgment on all of the violations. Mr. Johnson
I'm here,
does not establish.
Stephen Johnson,
So you're representative.
of the legal entity. That's right.
Default judgment, Secretary.
Default judgment. I'll be in court. When do I go? Do I know? Am I going to be notified?
Appeals judgment to the county court, which the various tolls were.
What county is this? Is this state or is this?
These are in Douglas, Adam, and Arapahoe County.
There are 3 different counties.
Okay.
You can appeal it within 30 days. These ones.
Thank you, Your Honor.
Where would you prefer me to be? Just right here? No, sir. No, sir. I addressed that in my paperwork. I've answered in the form of a demurrer, and I'm asking that, for evidence that the prosecutor and the DA, I guess the same person, that they are making a claim that the statutes and codes apply just because I'm physically in Colorado. Is that is?
Today's an motion to adjourn. Let's set the matter for motions hearing and trial. We'll have a file on the written. Today's not the day for that.
Right. So. Ask for a plea. If I enter a plea, then that acquiescence. Sir, I'm trying to make my case here, and you're interrupting me.
This isn't a trial.
I'm not asking for a trial. It's not a motions hearing. I'm not asking for that. I'm asking for the evidence that you have any evidence that the codes and statutes apply to me in front of you. Did the prosecution put any of that into the paperwork and prove that they have stance? So,
Motions hearing August.
are you asking me to plead today? Well, you interrupted me. You've interrupted me 3 times so far. I've not entered a plea. You cannot enter a plea for me. You are not my counsel. And so what I'm asking you right now is, can I enter a plea? Do you accept pleas, uninformed pleas? If I'm not informed, address me.
Do not interrupt me.
I'm sorry. I don't mean to interrupt you or disrespect you, but I feel that I am being disrespected at the moment.
I'm going to give you a motions hearing date. Your concerns can be raised.
I object, Your Honor. I do not agree to the motions hearing. I do not contract with you or this state. Who is bringing the charges against me? Can I ask that?
Motions hearing.
I object, Your Honor. I do not accept your contract for a motions hearing. I'm asking for evidence to prove that your jurisdiction applies, and you are neglecting to show that you have jurisdiction. Now, if I would...
Trial will be set September 5th and 6th, 8:30, on the 2-day trial and docket. All motions, including first witnesses.
This is not a motion, sir. This is not a disclosure. Is the Colorado Constitution in place in this court? Is the Colorado Constitution in place in this court? I'm guessing it is not, because you are not following it. Let the record show that the judge has left the courtroom and has abandoned his seat without answering the questions for evidence of his jurisdiction. I also want to state on the record that I have requested his oath of office and the oath of office of the county clerk, and those are not on file. My record's on right here, so.
I'm going to give you a motions hearing date. Your concerns can be raised.
I object, Your Honor. I do not agree to the motions hearing. I do not contract with you or this state. Who is bringing the charges against me? Can I ask that?
Motions hearing.
I object, Your Honor. I do not accept your contract for a motions hearing. I'm asking for evidence to prove that your jurisdiction applies, and you are neglecting to show that you have jurisdiction. Now, if I would...
Trial will be set September 5th and 6th, 8:30, on the 3-day trial and docket. All motions, including first witnesses.
This is not a motion, sir. Making a claim that the statutes and codes apply just because I'm physically in Colorado. Is
Today's an motion to adjourn. Let's set the matter for motions hearing and trial. We'll have a file on the written. Today's not the day for that.
right? I'm not real clear on like what's going on, and that's what I'm trying to do right now. I don't
Today's not the day for your motions to be heard.
But this is not a motion. I'm asking for the evidence that they need a plea today. Well, you interrupted me. You've interrupted me 3 times so far. I've not entered a plea. You cannot enter a plea for me. You are not my counsel. And so what I'm out asking you right now is you uninformed pleas. If I'm not informed, then how can I plead? Do you accept uninformed pleas?
We're not engaging in this conversation.
So you are neglecting to address me?
Do not interrupt me again.
I'm sorry, sir. I do not mean to interrupt you or disrespect you, but I feel that I am being disrespected at the moment. Jurisdiction applies to me, and if there is no evidence that jurisdiction applies, then that doesn't give you any authority to even ask for a plea. If I enter a plea, then that acquiesces the jurisdiction that you are claiming, and I have answered in the form of it. Please, sir, I'm trying to make my case here, and you're interrupting me.
This isn't a trial.
I'm not asking for a trial. It's not a motions hearing. I'm not asking for that. I'm asking for the evidence that you do you have any evidence that the codes and statutes apply to me in front of you?
Any other business?
I have business with the city. I believe that you may want to handle it now because my expenses go up as time progresses. I believe that you have been swindled and fraud. I'd like to pick up today. I'm about to quit asking you guys for it and I'll go get it and we can deal with that. I'm prepared to do that in a court. I have a valid court order for paperwork and I'd like to know when I can get that. This is definitely the appropriate time for that because, well, you're the board that handles my business, so it's not a comment. I'm formally requesting paperwork that I have a court order for. Just because he doesn't understand the rules of trial procedure is not my problem. I'll go get it myself. I'm letting you guys know. By the way, you owe me $5 million. Thank you for not objecting. Silence is consent when it comes to debt. You guys need to get another attorney.
All right, who else is there besides Mr.
Mr. Knight, and I know Mr. Veronica Trojan, I believe he has a PC affidavit in hand.
Okay,
Hello, thank
hello,
you.
you're welcome.
Okay, so.
Did you have enough time to read it?
I did. I would still like to speak that the notice of dishonor stands, even though the complaint affidavit was provided to me a little bit late. And I do want to make a legal argument against this probable cause affidavit. I just want to ask the state a question. Where did these officers receive this information?
I don't believe I'm under any obligation to answer Mr. LeBron's question.
Okay, sir, this is how let me just tell you how this works so you know, okay?
Okay.
I look at this affidavit filed by the police officer, and if it appears on its face, that doesn't mean that you did, but just on its face, if it appears that you committed the crime of aggravated battery, then I find probable cause. That doesn't mean today's not your trial day.
No, I understand that completely. What I'm trying to get at is that they just say that they made contact with me at a residence, which I don't know what that has to do with the alleged incident. And then it says also that they said that the crime was actually committed, which I don't know how somebody could swear to that when they never saw it. And I believe that this complaint affidavit is mostly hearsay. So based on hearsay, if an officer swears to hearsay, does that create presumption great, or is that just one person saying something to another and then swearing to it? Because I think that's kind of that makes this complaint affidavit moot and very ambiguous, and it puts me in a state of embarrassment where
where I'm faced to go towards a trial with no actual facts, just presumptions and assumptions and hearsay. And to my knowledge, which is very limited, compared to yours, I would say that this is a hearsay complaint report affidavit, and where's the proof? Presumption is there, maybe not great, and I would say that this is defacing the court. To present this to the court, I think would really do a great disservice to the court. And furthermore, I would say that I know it's not my trial date or anything like that, but if I had evidence to show that this victim is actually in fact lying, and that this document that we were ready to put inside the court would be a police report, and what would the court's position be on that? Because I think that this is all, hearsay, and furthermore, I could show proof that the alleged victims are lying.
Okay, here's the thing, sir. This is a non-adversarial hearing, so that means all the state has to do is present an affidavit and/or they can bring live testimony into the court, and it's just to that and that alone that I look at. So,
Okay, well, I would say as my legal argument, excuse me, I don't mean to cut you off.
No, go ahead.
Respectfully, I would say that this case has no corpus delicti, and if the state's position is that it does have corpus delicti, then I would like the state to meet the elements of the crime right now to make their case, because I just don't think so. I don't believe that this case is corpus delicti.
okay, sir, based on, I understand your arguments and they are noted, and that doesn't mean that you're gonna be found guilty of this. You might very well be found innocent. I appreciate your arguments. But for purposes of probable cause, the court is gonna find probable cause for aggravated battery. I can tell you the one thing that I am gonna do is I do it in all these aggravated battery cases, 90 out of 100.
Yes,
No
ma'am.
contact with the victim with the initials JM and WMR. That means through third parties, social media, just stay away from them, okay? So as far as bond in this case, state, what are you requesting for bond?
Well,
Your Honor, I'm going to be requesting a $15,000 bond, pretrial release of the GPS. I know you said his co-defendants at $10,000. However, one, I would argue, based on the allegations, I believe Mr. LeBron's involvement is more aggravating than his co-defendants. One. Two, his criminal history. 2009, fleeing and eluding law enforcement in a DUI. 2008, delivery of cocaine, he violated probation. 2008, resisting without violence. 2005, possession of alprazolam, he was sentenced to just over 17 and a half months state prison. 2006, burglary of a structure, he received the same sentence. 2005, grand theft auto, he received the same sentence. 2004, possession of cocaine, MDMA, possession of cannabis with intent to sell, resisting with violence, battery on a law enforcement officer, violated probation, just over 17 and a half months state prison. 03, possession of alprazolam, VOP, again, just over 17 and a half months Florida state prison. End of record.
okay, may I say something, Your Honor?
Sure, let me just premise it on this, okay? State is asking for, so I ordered the no contact order with those
Yes,
two
I
alleged
understand.
victims, and the state is asking for a $15,000 bond. We actually set your co-defendants at a $10,000 bond. So what is your response to that? And I'll let you say your other arguments as well, too.
Sure, absolutely. My response to that is what the state is stating is remote, and in the past, according to the Fair Debt Collection Act, I don't think that you're supposed to go past 7 years on any charge per se. So I would say that those charges when I was an adolescent are remote and in the past, and given the fact that I haven't gotten in trouble for a substantial amount of time, I would like to present that to the court. I haven't been found guilty of this allegation, and I would say that I'm a staple in the community by doing a lot of community service. I sell a lot on Amazon. I donate to my local women and children in distress. So I don't want the court to shed a light just on the allegations. I do have a positive impact on the community, and I would like the court to consider lowering my bonds, not only for the fact that I can't meet that financial obligation.
Well,
So
right
a high
now-
bond is
well, right
equivalent
now-
to no bond at all.
No, I know, right now, there's no bond set at all. So we
Sure,
have to set a bond
understandable.
today.
Sure, well, the 15,000, I would never be able to meet that. That's beyond
What
my
do you do,
financial
what do you do
capabilities.
for a living, sir?
I do a lot of e-commerce, so I basically, buy returned items and I sell them on Amazon. I just started, my company's under a year old, so, just to be fair, I'm self-sufficient, I'm my own business owner, but I'm not in a financial position to, in any way, and I don't want to, make it seem like I am. I'm not in a financial position to make a $15,000 bond or a $10,000 bond. I've lived here for over 20 years, so I don't, I have strong ties to the community, and I would like the court to consider possibly reducing that down substantially so that I could collect my evidence and fight my case in a competent way, because there's no way to really do that here, with all respect.
Okay. Do you rent or own, sir?
I rent.
How much money do you?
Tamashiro here. Some of you on Hawaii Island and maybe other areas of the world might have heard about four court observers, four Hawaii National Court observers. We were in Waimea Court and we were defending a man's right to due process and the right to travel. We had asked quite patiently and quite respectfully right out of the beginning that could we have our case, our young friend Tamison Carlos Elazar, could we have his case be heard in the alphabetical order? And instead what has happened to him several times now is because we do challenge jurisdiction, we do ask, has any man or woman claim that any of us have done any harm? Right now this is a case of state of Hawaii, a corporation versus this man or that man. Typically, those people are in their world straw people anyway. But the real man, Tamison Carlos Elazar, his grandmother, myself, and another friend, Terry Wen, we were there to demand our unalienable rights to full disclosure, due process, to examine claims and facts and evidence. Start out, as I said, very respectfully and quietly. But as soon as the judge, her name is Kanani Laubach, the woman, as soon as she realizes there's people, four people, real people, ready to challenge her in jurisdiction and due process, let's engage in a meaningful, respectful dialogue, she immediately, truly, within a second, like she was prepared, grabs a piece of paper and starts reading charges of contempt of court. From that moment on, she's blocked out all possibility of having a discussion and in fact threatened us with contempt of court and jail immediately. This egregious, disrespectful behavior gets us excited, gets me very excited, and eventually our pleading with her, our asking her, please listen to us, have a discussion with us, which she doesn't want to have. Because everybody in the courtroom, the judge, the bailiff, the clerks, and all the people sitting in the courtroom, we know Hawaii's true political status. And I think it's time that we peacefully, but in honor, there's no harm here. We would like due process to examine our claim, our facts and evidence. And it's your turn now, judge or prosecutor. Adult people engaging in lawful, respectful dialogue. Well, like I said, she just starts reading charges. It gets very heated. We decide we're going to leave now. Hello, we're going to leave because you're not giving us due process, which means she's perjuring her oath to due process and serving and protecting. So much for that. We can't leave because the police, the bailiffs, are blocking the way, and then one of them grabs Terry, yanks her arm in the back, and starts to handcuff her. Now I'm mad. Sorry. I get mad. She starts attacking us, basically, charging us, saying, you're all going to go to jail, and here's why, reading the charges. Fortunately, she gives me a moment. She's thinking that I'm going to go cross the bar now, and that I'm in her jurisdiction. We rebuke all false claims, false contracts, false presumptions, and we've filed for years now about our true political status. And I do have a moment using the state of Hawaii's video system where I am able to bring facts and evidence that are relevant to this case and so many other cases where the state of Hawaii, which cannot prove jurisdiction, is actually harming people, the agents of the state of Hawaii. Okay, so I want you to check this out. We're going to continue to stand in honor. I am learning to be more peaceful about this, but maybe you'll understand why we get pretty hot, because there was no due process, there was no respect, no examining claims and evidence, just threats that we indeed ended up being harmed, going to jail for 30 days. We're out, we're back, we're going to do the best we can, we're going to demand the truth, we're going to share the truth, and we're going to do it with aloha. Okay, God bless you. Thank you.
Case 26 and page 24, Hanoi Conti.
Excuse me. I took off my work because I want to support a man who will stand in honor. And I heard you guys would skip his name last time too. And we cannot allow you to keep doing that.
Okay, so I'm going to advise you, sir, regarding summary contempt of court.
No.
Yep.
Listen.
No.
Ma'am.
No. This happens every time. Okay, so I'm gonna advise, because this is, look what you guys do every time you guys come to court. This is what happens. You cause a disruption.
Page 24, Hanoi Conti.
Excuse me. I took off my work because I want to support a man who will stand in honor. And I heard you guys would skip his name last time too. And we cannot allow you to keep doing that.
Okay, so I'm going to advise you, sir, regarding summary contempt of court.
No.
Yep.
Listen.
No.
Ma'am.
No. This happens every time. Okay, so I'm gonna advise, because this is, look what you guys do every time you guys come to court. This is what happens. You cause a disruption in my court, and I cannot allow it. So I'm going to advise you of summary contempt of court. We have a vehicle to, okay, so I'm going to advise you of summary contempt of court. If you willfully cause a disruption in the immediate view and presence of the court, I can take you into custody and sentence you to 30 days in jail forthwith. So if you want to continue disrupting the proceeding, I have to advise you, I'm going to charge you with summary contempt of court. I'm going to find you guilty and sentence you to 30 days. Okay, all right, so I'm going to charge you, sir. What is your name? I'm going to charge you, sir, the male individual with a navy blue shirt with initials RVKA on it. You are hereby charged with the violation of HR Section 710-1077-1A, that you did recklessly engage in disorderly or contemptuous. What's your name, sir? What's your name, sir?
I'm Gene Tomashiro.
Gene Tomashiro. Okay, so I'm also.
Write it down.
I'm also charging you, Mr.
You can charge me with anything. The first thing you gotta do, man, is you gotta prove jurisdiction. And all these people in here know this. They know this. Nobody's doing any harm and you're extorting money.
Recklessly engaged in disorderly.
Yeah, why don't you talk to me man to woman, please?
Because you're not showing me any respect.
I'm showing you respect. I want some due process. Please stop doing that. Can we talk like real
On my
people?
calendar, sir. You're not on my
I
calendar.
tell you what, this crime affects everybody in Hawaii.
Committed during the sitting of the court.
This is our court. This
Okay.
is the people's court. Go ahead, hold your court, please. Continue to hold your
We're
court.
gonna leave. We can leave now. We're gonna leave now because you don't give us due process.
Ma'am, what's your name?
People's court.
What's your name, ma'am? So the court is also
Continue
going
to
to
hold your
charge the
court.
female individual
These
sitting
guys
between
know.
the two.
Sister, these guys know.
males.
You gotta stop Shibai over here, okay?
I'm also charging you, ma'am. Hereby charged with the violation of HR.
You and your
We're gonna need 3 separate vehicles to take all parties to jail. You 3 are hereby charged with the violation of HR. Section 710, 777, 1A. All did recklessly engage in disorderly or contemptuous behavior committed during the sitting of the
You guys
court
witness.
in its immediate view and presence.
You guys
and
all
directly
witness.
tending to interrupt.
So you know, we require of you,
First, sir,
Judge.
the Navy.
Put it in writing. Put what you want to say in writing and send it to us.
You understand the charge, sir. The court will request no response. Female as to black and white. Okay, ma'am, in the Navy sweatshirt, the court is also gonna charge you in violation of HR section 710, 777, 1A.
You're harming a woman.
Recklessly engaging
You are harming a woman.
or contemptuous behavior.
You are harming a woman.
Committed during the sitting of the
Robert,
court, immediately
You're making a mistake.
and directly
You're making a
tending to
mistake.
interrupt the court's
And we can
proceeding
prove
or
it.
impair the respect to the court's
Everybody here know.
So ma'am, what is
Just
your
calm
name?
down. We're gonna
In
be
the
all
blue
right.
sweatshirt.
All you guys witness that.
Ma'am, what is your name? Ma'am, what is your name? In the blue
You got
sweatshirt.
any reporters?
So the court
Report
will
this,
know that
please.
the female party in
No
the blue
harm.
sweatshirt and black jeans.
I'm a woman.
is in charge.
This
The
is
court
our
will
court.
review
This is the
offense
people's
as a
court.
petty
There's a
misdemeanor
crime being committed
in
here.
the immediate view and presence of the court.
There's a crime being committed
Therefore has the
by
power
this
to order
man
summary
who's holding me
conviction
hostage.
and disposition. Charge is a petty misdemeanor.
I'm a woman. Is there a man or woman here claiming I do harm?
Jail as or $1,000 fine. Accordingly, there is no right to a jury trial. So the substance of the charge should be rated based on the following behavior. So the court first did a male in a navy blue shirt. The female in the black and white shirt with the glasses on top of her head also committed contentious
I'm a woman.
behavior
You are harming a
by
woman.
interrupting the court's proceedings
You're
and
harming
displaying
me.
the respect to the
Exercising
court's
your right.
authority. The male party sitting
You're
down
harming me.
was identified as Jean Comashero, also did the
Dennis?
following: engage in contemptuous
Dennis?
behavior by
Yes, I'm a woman.
interrupting the court's proceedings
We
and
know all of
impairing the
that
respect to the
from
court's
all of you.
authority. And the female party currently
What took place
handcuffed
today?
in the navy blue sweatshirt did also engage in contemptuous behavior, interrupting the court's proceedings.
This is
or
our
impairing
court.
the
This is
respect to
the
the
people's
court's
court.
authority. So, male party in the navy blue shirt, do you understand the charge? Court will reflect no response. Female party in the black and white t-shirt, do you understand the charge? Court will reflect no response. Male party sitting down, Jean Comashero, Mr. Comashero, you understand the charge?
I'm a woman being
Court will
harmed.
reflect no response.
Oh, no, I have a response. I have a response. Stop.
Harmed.
Don't just talk out of the piece of paper. Be a real person, okay? Listen,
I've been harmed.
I understand that I comprehend that you are operating without due process. Hello? Are you deaf and dumb? Come on. Yeah, exactly. Hello? I'm standing on a... That's how afraid you are, Judge. Yes, you heard me.
Come up here and tell me.
Let's go. Come on, let me go. Let's talk right now.
Mr. Comashero,
Yes, you heard me.
come up here and tell me what do
Let's
you want to
go.
say
Let's
regarding
go.
the
Let's
right
talk
here
right
on.
True Freeman, any comment?
We're on the record. We're on the record in case number 4:17 CR 3038, United States of America versus Michael Wayne Parsons. Counsel, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp, Assistant United States Attorney on behalf of the United States.
And John Vanderslice on behalf of Mr. Parsons.
Are you Michael Wayne Parsons?
Are we on the record?
Yes, we are.
Good morning, Your Honor, or good afternoon. Let the record show that I was just brought in here by force against my will, and the officer directly behind me assaulted me, threw me to the ground, drugged me in here. I've got broken ribs, broken arm, multiple injuries from previous assaults, and I just sustained another one by this gentleman behind me. I want that to be on the record, first of all. Also, the fictitious person and the birth certificate have been surrendered to the court.
Please stay seated. You must stay seated.
Birth certificate there. Let the record show that by special appearance, Ambassador Parsons of the Chilcotin Nation, country of the Chilcotin, the beneficiary, I'm here and I reserve all of my rights without prejudice, UCC 1-308, the Vienna Convention on Diplomatic Relations, and the Montevideo Convention, having already surrendered the fictitious person and birth certificate into the well of this court. This court lacks jurisdiction, and I have no business with this court. Am I free to go?
No.
I will instruct you as the trustee to dispose of the charge, pay off any debts, and compensate me for the damages.
Are you Michael Wayne Parsons?
I am not the fictitious person that you seek. You're seeking, according to this affidavit, a corporate entity, Michael Wayne Parsons. I am not that person. I'm not the fiduciary, surety, or trustee for that corporate entity or trust.
All right.
I'm a live man. This court is not an Article III court. As an ambassador of another country, according to the Constitution, Article 3, Section 2, all matters pertaining to ambassadors, the original jurisdiction and sole jurisdiction is with the Article 3, Section 2 Supreme Court. This is not that. This court lacks jurisdiction.
All right. Are you saying you are not Michael Wayne Parsons?
I am not the person in the indictment. That is a fictitious person.
What is your name? What is your name?
I am Ambassador Parsons of the Chilcotin Nation,
Yeah.
country of the Chilcotin. I am not the person, the fictitious person that is in this indictment. That is not me.
All right. Now, Ambassador Parsons, what is your first name?
I'm referred to as Ambassador Parsons for the record.
All right.
I do not consent to this forum. I do not understand this forum. This gentleman just approached me moments earlier, and I tried to ask questions. He could not answer any of the questions.
All right. What I'm going to do is, first of all, we'll have to have an identity hearing. And interestingly, my understanding is that you have refused to be processed by the marshals, which would include your DNA and your fingerprints. You are hereby ordered to submit to processing by the marshals. They will go ahead and do that, even if it's necessary to do it involuntarily.
I would like to be heard on that matter. I don't consent to that under the United States Supreme Court ruling under Title 42, 2000 BB, the Religious Freedoms Restoration Act. It is against objections. I do not do TB shots, or I do not do any unknown foreign substances into my body, and they're trying to force a TB test upon me is in violation of United States Code and Supreme Court rulings that say that if I'm not symptomatic, they can't force me against my will. I've never done a TB test. I don't consent to those now. It is against my rights as a human being given to me by my Creator not to give up my DNA. I'm not.
We're on the record. You're not? Please stay seated.
Good afternoon. No, ma'am, I got no advance notice. I don't even know why I'm here, and I would ask for continuance to be given advance notice so that I can prepare, because I have no clue as to why I'm even here.
Okay, we're going to go forward with what we're going to do today, and if as we go through the process, are we on the record? Okay. If as we go through the process, something comes up that you're truly not prepared to respond to, then we'll take that up at that time. But I think we can clarify and keep some. My point for this today, sir, is to try to clean up some issues that you've been presenting to me and that you've been presenting to me, so that we can keep you apprised of your case, keep you informed on how to represent yourself in this matter. The whole hearing is for your benefit. I don't think you want it to be continued once you hear what the goal is. All right? We're on the record in case number 4:17 CR 3038, United States of America versus Michael Wayne Parsons. Counsel for the government, enter your appearance.
Good afternoon, Your Honor. Jan Sharp appearing on behalf of the United States.
And I see Mr. Parsons is present as well, and Mr. Vanderslice is standby counsel for the court.
No, ma'am, I'm Ambassador Michael Parsons. I am not the defendant, as I've asserted before. That is a corporate fiction.
All right.
I've got a document here I'd like to present the court at this time. Given the fact that I've not been given advance notice of this hearing, I've just been brought in here by force against my will. I object to this hearing, and I would ask for a continuance at this time. But at this moment, I want to present to the court a petition that I have served upon the 8th Circuit Court, given the fact that I have not been served with their ruling for a stay pending the orders of this court, but yet I've been advised verbally that they have potentially denied or dismissed it. I have a petition that has been sent to them as of yesterday that I'd like to present to this court, so this court is fully on notice of that petition before the 8th Circuit before it proceeds any further.
You can provide. I want to make sure you understand, sir, that I have already determined, based upon my research, that your appeal to the 8th Circuit on the issue of tuberculosis testing did not divest this court of jurisdiction under the underlying matter, being the criminal case. And so I'm not divested of jurisdiction. Plus, I am going to give you a copy right now of the order that came from the 8th Circuit that has determined that your matter is not before them at this point. So
the issue before the 8th Circuit was not just TB, it was also a motion to dismiss that they were taken up in my petition to them. Some pages I went at lengths about the fraud that's being committed by this court and by Your Honor, who's putting false information into the record and not giving me an opportunity to rebut that information on the record. And therefore, this court is committing a fraud upon me in many ways, given the fact that, number one, you appointed Mr. Vanderslice before I was ever brought in here, and he immediately withdrew, not on the second day, but on the first day. And then you immediately appointed him as elbow counsel just so that you could obtain jurisdiction in this matter. That's fraud upon the court. And then in this most recent response position that he was appointed after I was brought into the court, and then he's been in the vicinity of me. But ma'am, with all due respect, this box of Kleenex in front of me has given me more counsel than Mr. Vanderslice. Mr.
Vanderslice, you may approach.
Has done nothing to assist me in this matter. He's not filed a single motion on my behalf. I've never waived my right to legal counsel. I did not ask for an attorney, as you asserted. I asked for legal counsel, which I'm entitled to. I'm entitled to know the true nature and the cause, not the forum, but the form, F-O-R-M, of court. Is this an admiralty court?
And as I've told you now in writing twice, and I've told you verbally, this court has been formed under Article 3 of the United States Constitution. It is the United States Federal Court for the District of Nebraska. I will not repeat that again.
But you're not answering the question, ma'am. The form of the court, is it an admiralty? Are you operating an admiralty law? Is this mercantile?
I can, but that's not what this case is about.
Are you operating admiralty law?
I can, but that's not what this case is about. Are you in this matter
operating admiralty law?
I'm not applying admiralty law in this case.
What form are you operating under? Statute
I
law?
am done answering your questions, sir, and you are done talking for a moment.
I have a right to know.
You are done
No,
talking.
ma'am, I'm not done talking. You're going to listen to me. I have a right to know the form of this court. I will not proceed. I do not consent to this matter. You are relieved of duty. I will not proceed any further. You are now served. This is the motion that relieves you from this court. This matter is adjourned. This matter is dismissed. We will not go any further until you disclose the form of court that you're operating under.
Okay. Here is what I convened the hearing for. And we're going to take up those matters. If you choose to participate, sir, you may. If you choose not to, you don't have to. One of your claims is that you have not received the discovery from the government, and I received information back indicating that for whatever reason, the flash drive is not available to you. At what happened to the flash drive? I don't have to at this point. My real concern is that you have an opportunity to see and read and listen to all of the discovery. And so Mr. Sharp responded to that yesterday, I believe, with a proposal of what to do today at this hearing. Mr. Sharp, tell me what your plan is.
Your Honor, I have brought another copy of the flash drive, which Mr. Parsons in court, hopefully with the court's approval that this is the proper procedure to follow. Also, one of his complaints in his filing was that there was a copy of the search warrant that was missing page 14. I went back through the discovery that was originally sent to Mr. Vanderslice, and Mr. Parsons is correct. Page 14, the signature page, was missing. I have a full set of that search warrant that's contained here that I also intend to give to him. I also have printed out all of the documentary evidence that was on the flash drive in a hard copy, which I intend, again with the court's approval, to give to Mr. Parsons. Now, on this flash drive, and I was explaining this to Mr. Parsons before we began today, there are many, many jail calls, perhaps 200 plus, 225 plus. The vast majority of the calls on that on this flash drive have absolutely no relevance to this case whatsoever. In the government's, it's the government's position that there are less than 5 relevant calls or conversations or video recordings that are relevant to anything in this case. I am willing, if you by number and date, exactly which 3 to 5 conversations the government believes is relevant. And I'm also willing to say that we won't use anything that's not amongst that 3 to 5, whatever I identify, moving forward.
All right. You
Your
may
Honor,
hand that information to Mr. Parsons at this time.
Your Honor, I
Actually,
object.
the flash drive, I'm gonna,
I object because I filed a motion to suppress that evidence, given the fact that Your Honor told Mr. The Assistant U.S. Attorney that he had until 14 days following the 18th to serve that upon me directly. You formed him to serve it directly to me because I was not represented by counsel at that time. The 2nd of January came and went. I had not been given it. This court did not advise him to give it to somebody else or anything else. I did not know anything about it, nor did I see any of this until after the 16th of the trial, and I have a right to a suppression of any evidence that the U.S. Attorney had or would have had access to up until the 2nd, because it fell on the 1st. That was a holiday. The 2nd of January was the deadline. He did not meet that deadline. Therefore, he has no right whatsoever, no grounds to submit any evidence beyond that point in this matter. That's why I moved this court to suppress that under your own rules that you sent me. I had followed that, and I ordered or I petitioned this court to suppress that, and I demand that that be done at this time, because otherwise this court is just working as it appears to have been doing all along on the side of the United States of America, the plaintiff, who, Your Honor, inadvertently someone slipped in my information that clearly you were working for the United States of America and doing research on the TV issue from the very beginning. That's prejudicial. This whole case is prejudicial, and if you're not going to follow your own rules of suppression of evidence and demand and follow my demand of suppression in a speedy trial, then this whole thing is just a kangaroo court. It's a fraud. I think we can do better than that. So I move that at this point to recognize my suppression of evidence motion, that that evidence is not valid. It can't be used. Anything that he had up into or could have had a 2nd of January is void, and it can't be used. And I move that it be suppressed.
Based upon your statements, I assume that you have not received the findings or recommendations that I already put out on that same motion. I mailed them to you on the 7th. It's the 9th, so that makes some sense that you may not have gotten it yet. Mr. Vanderslice, you may approach.
I object. Mr. Vanderslice does not.
He is just operating as my courier. Thank you, Mr. Vanderslice.
That let the record reflect that Mr. Vanderslice is a courier.
He is operating as my courier on that particular issue. And doing better than a box of Kleenex, I might add. So now the next thing is you now have a copy of it that was handed to you, and I'm going to make it of record that was handed to you.
I have not had an opportunity.
In this case, sir.
I have not had an opportunity to review this, man. My hands are shackled. You've got me handcuffed. I can't even get into my own papers.
I'm not talking about the what I just handed you. That's not what this hearing is about. You've received the copy of the government's evidence at this point in time. You've received a new flash drive.
No, ma'am, I have not received it at this time. That is not true. I don't have anything. A flash drive that I don't have. I'm in a jail cell with no computer,
and if
no access.
If you will be kind enough to be respectful enough of me, I will tell you what my plan is on this. First of all, my understanding is that Saline County is willing to allow you to view and look at the flash drive. Am I correct on that, Mr. Sharp?
Correct, Your Honor.
All right. Secondly, if that poses an additional problem, I have contacted the IT department of the court here. And if it continues to be a problem down in Saline, you can be brought here, stay in the holding cell back here, and the court will provide you with a computer so that you can view it here if need be. And so I believe that resolves all of the issues that you've brought up about not being given access to look at the flash drive. I hope you will understand that we've never done this before for anyone else because we've never had this issue brought before us before, and it's always been able to be resolved. And so people are figuring out different options. And so if that poses a continued problem down in Saline, you need to let Mr. Vanderslice know or the court know, and we will have you brought to the holding area here, and you can look at your videos and you can listen to your audios sitting in the holding cell here in the courthouse.
This does not address my motion to suppress the evidence that was filed with this court well before the deadline, and this court has not responded to that affirmatively, and I demand that all of this evidence be suppressed because it was not provided to me before the deadline. Today is long past January the 2nd. I do not consent to discovery that could have and should have been given and was ordered by the court to be given directly to me by the U.S. Attorney. And the U.S. Attorney did the court's order. Therefore, I am enjoined by the rules of the court, and also that I move that that be ordered and done today, suppressing that evidence as my petition demanded.
And that motion is denied for the reasons set forth in the findings, recommendation, and order that is currently in front of you in paper. Now, the next matter that I wanted to bring up is that you had requested that this matter be transferred to North Platte. Mr. Sharp was given an opportunity, or has been given an opportunity to respond to that by February 14th. I'm not asking him to respond to that today.
I did before I left this morning, and I
have not seen it, so hang on.
And I would also advise the court that I'm going to hand a copy to Mr. Parsons because he hasn't.
Actually, I just gave him a copy that I had already printed out, Judge.
All right. So, just so that you understand, sir, how I would like you to make sure that you get a full opportunity to respond to this.
But see, I'm not here. I'm looking at document.
I'm not asking you to respond to it right now. What I'm trying to tell you is what I expect of you going forward. I want you to read the brief. I don't want you to, I'm not asking you to argue it right now. I would like you to read the brief now that you have all of the evidence in front of you.
But I don't have, that's not true. I don't have all the evidence. I'm looking at, I don't know where document 54, 53, 52 are. You're just handing me document 51. There's 3 other documents that I don't have. That's the problem with this court is I'm not being served. I don't have legal counsel. The court
and
is
so
ordered.
that is the last question that I was going to bring up today. And for this one, I'm going to have Mr. Sharp leave because I'm going to be asking information about financial stuff. Thank you, Mr. Sharp.
May I provide this document that I've tried to offer the court 3 times now to the court so the court can review it before we proceed?
Currently, unless it is talking about the right to counsel, which is the only matter I have in front of me right now on my agenda, and by the way, this is my court, and so I'm going to create the agenda for today.
So this is not the people's court, this is your personal court.
This is my courtroom right now, and you will...
And that's what this addresses, is this is your courtroom. It is not a constitutional court of the people, and that is the problem. You're operating a business, correct?
I'm going to ask you a few questions. You have consistently, sir...
It's a business. You won't answer the question.
This is not a business.
You're concealing the fact that you're operating a business, and I'm not here to engage in business with you. I'm not here to engage in commerce with you. I don't have any contract with you. I don't have a contract with the U.S. Marshal, which is also a corporation, and that's what this notice is about. Unless you've got a contract that you can show me where I have violated the terms of the contract, I don't consent to this. I'm not here to make a contract. I don't consent to these proceedings.
All right, let me ask you a question. Do you want an appointed attorney?
I want you to let me
I want
alone.
a yes or no
I want you to
answer.
free me from this hell and let me go about my life because I don't have a contract with you or the United States of America or the U.S. Marshal Service. You're committing a fraud upon an ambassador of another country, ma'am.
Do you want an appointed attorney? You send me letters saying that you want that, and then you don't send me the information.
No, ma'am, that is not true. Do you know the difference between an attorney and counsel?
Okay, do you want an attorney?
No, I don't use attorneys because attorneys work for the court. They are not counsel. They are working for the court. Their oath is to the court and not to me. The Constitution of this country does not give me the right to an attorney. It's recognizing my right to legal counsel.
Okay.
You've denied me access to legal counsel. You've said that I've got access to a phone to make free phone calls to this gentleman who won't take my calls. He's already withdrawn, and he told me personally, do not call me again last Friday a week ago. Is that correct?
Okay, we're going to
comment on that, Judge.
I will call as a witness Mr. Vanderslice I want to put him on the stand, and I want him to perjure himself today.
So
we're going to have a hearing. We're going to have a hearing. Mr. Vanderslice, would you please?
No. You haven't figured out, sir, that I'm the judge.
I don't know what you are because I don't know what kind of form you're operating. You're operating a business here.
All right.
You can call it a judge.
Do you want appointed counsel?
I want you to take this document and read it before you go any further.
All right. Let me read it.
Well, I'm shackled and seated, so I'm kind of...
We'll let Jerry be the courier on behalf of the court at this point. Thank you.
That goes with it. I did, but I don't think y'all got it. It went out yesterday. That's a different one. Yes, ma'am.
Okay.
I would move to subpoena the phone records from the jail to Mr.
If you want me to read this, you have to quit talking. All right. I see that you're not consenting. I see that you believe that this is not a court over which that can exercise jurisdiction over you. And I see that you're demanding a stay of this case at this time. I believe what you're saying is that the matter is before the Eighth Circuit at this time. Is that what you're saying?
I'll be appealing the matter from the Eighth Circuit Court to the U.S. Supreme Court.
All right.
And
that is certainly, it isn't called, just so you know, it isn't called an appeal. It's called a writ of certiorari.
Actually, no, ma'am, under the Article 3, Section 2, it's not a writ of certiorari, which is a request for permission. It's a demand. I'm demanding rights here. I'm not asking for permission. I'm not a subject citizen. I'm an ambassador. You're a corporation. I'm not. I'm a live man. I'm not a corporation. I'm not a thing. You're treating me like a thing and like property. I'm not a thing. I'm not your property. And I wish you could learn that, because we'd get along a whole lot better. I've harmed nobody. There's no victim in this. You've shown me nowhere where I'm subject to your jurisdiction.
All right. Do you want appointed counsel?
Show me subject jurisdiction first. Show me subject jurisdiction.
Do you want
please.
Appointed counsel?
I don't understand what you're talking about, because you're not disclosing that you're an Admiralty operation right now.
Do you want counsel appointed to you to represent you in the proceedings at no cost to you?
Until you answer my question, I can't respond, because I don't know how to respond. With all due respect, ma'am, if you will tell me the form of court you're operating, then I'll know how to respond.
I've already told you that.
No, ma'am, you haven't.
All right.
Is it Admiralty?
Judge, could I
Administrative?
say something, please?
Absolutely.
All right.
I object. You not even representing me. You filed a motion that you want to take my calls.
Move to withdraw as standby counsel. The ambassador and I, and my boss, I've spoken with Mr. Stickman a couple of times about Mr. Parsons, the ambassador, and to do what I can do to assist him in many different ways, even though he's not satisfied with that. I've tried to answer his questions in ways that I felt were reasonable. I've tried to be available for phone calls, and haven't been available all the time, because, as you know, I was in OCC yesterday. I was in Saline earlier this week. I traveled to visit my clients, and so I have appointments. But I'm in court, so I'm not available at his beck and call. There have been many voicemail messages left on my voicemail. I listened to them all. One day there were 6 of them that go on for anywhere from 5 to 10 minutes, many times, in a mode where it's hard for me to hear because of whatever phone he's calling from. I visited him once in his isolation cell, and they wheel in what appears to be something that looks like the old type of phone that you would put money into, but I think it plugs into the wall. But it doesn't give me very good reception. But in any event, my point is that at this juncture, Mr. Parsons, Ambassador Parsons, and I are not getting along. And I think you can recognize what I'm saying just from the colloquy that you and I are having. I try to do what I can to answer his questions, but the answers that I have aren't satisfactory to him, or I just simply tell him, I can't answer that question. And that's not satisfactory to him either. I told him right up front that I have represented folks in the past that go through their case in a similar manner to the way that Mr. Parsons is going through his case, which is a very unconventional way, as you well know. I don't think I can be any assistance to him as counsel or as an attorney or as anything that realistically is helpful to him. I can give you an example. Well, that's not completely true. I've tried to send him documents. I've sent him blank subpoenas off the district court's website. I've sent him his docs. I've tried to keep up with the filings and send those to him as I can. There is a lag between the mail that I send and that he gets, from anywhere from a couple of days to maybe as much as a week. And so that puts Ambassador Parsons at an extreme disadvantage related to being up to speed like the other folks, like you, like Mr. Sharp, like me, when we get everything electronically immediately.
Correct.
So, I mean, there is that time lag, but notwithstanding all of that, all of those issues,
Man, I'm moving
Mr.
on. I'm
Parsons
sorry,
and
y'all.
I are not.
Settlement? And sir, are you, in a position to settle or do you want to settle that up front?
Basically, I guess has the prosecutor submitted any of the evidence that I requested from last time? You guys recall the
The
evidence?
defendant has the discovery.
Is that a yes, that you've submitted evidence
Yes.
of what I requested?
We have the police report.
Okay. The police report is that evidence of jurisdiction?
Yes.
And you can show me that? Where in the police report that it proves jurisdiction?
It states the location, which is in the county of Napa.
Alright, so at this time, are you ready to set the matter for trial, sir?
Like I said before last time, that I was coming here because I know I don't want to waste any of your guys' time. I don't want to waste my time. That's why I had the intention and still have the intentions of pleading guilty just to get it all wrapped up. I just want to make an informed plea. And for me to make an informed plea, I just want to make sure the prosecutor has done their job and submitted any evidence of jurisdiction on the record. The prosecutor said on record they don't have any evidence of jurisdiction and couldn't provide it that day. And I recall them saying something that they'll be able to bring it up next time, but I still don't see anything. So, I conclude that this just be dismissed on those grounds.
Right, we talked about this the last time, I denied your request to dismiss.
On what grounds?
There's no basis.
There's no grounds to deny.
There's no basis to dismiss your case today.
Has my demur, my motion, been opposed?
We've already dealt with your demur, sir, and so now we're at the point where you don't want to resolve. You keep saying you want to plead guilty, but
I have the intentions of pleading guilty.
so then either that happens today, or we set the case for a jury trial, and if you want to resolve at your readiness conference, you can do that as well.
Okay, well, I'm here today to just wrap this up. I mean, can jurisdiction be challenged at any time? That's an element, right? I mean, what are the elements of accusations?
Your attorney, neither can Ms. Quaid, as she represents the people. But you need an attorney to assist you. You said you have that right. You can either hire your own or you can appoint a public defender. Last time you said you did not want a public defender, so I'm going to make sure again. Do you want an attorney to help you with your case, sir?
I don't want to give away that right, but I don't see how we can even go forward if the prosecutor can't prove jurisdiction.
Sir,
I
you
don't.
have to listen to my question and answer. Do you want an attorney to help you or not?
No, I don't.
Okay, then if you want to resolve this case today.
Love to get it resolved today.
Right.
And like I said, I have.
Do you want to take that offer?
What's the offer?
Is it still the same list of items?
Yes.
Okay. You would be pleading to counts 1 and 4. Anything else would be dismissed, so that would be the 2800 and 24002. So specifically, count 1 is disobedience.
Disobedience?
Plain an officer, and count 4 is unsafe condition of vehicle. Those would be the 2 charges. Everything else would be dismissed. You'd be placed on 2 years of summary probation. You would get credit for any jail time you've already served, no additional jail. There would be minimum fines of $70 for each charge, plus a $150 court restitution fine if you set payments. And that's it if you want to agree. Looks like the offer is probation denied and 9 days jail. You don't want to put probation. So do you want to take out one of those?
For me to make informed pleaded would like a few things, and I just want to make sure the prosecutor has the burden of proof, right?
Yes, sir.
And I'm presumed innocent of all charges, and I didn't commit any crime. I didn't hurt anybody.
So
No, but no one's harmed.
That's telling me that you don't want to resolve and perhaps the matter set for trial.
I never said that. And I'm just trying to figure out the best plea to make, and you know, if the elements of the accusations is injury, harm, or damage, or redressability, isn't that part of the elements of accusations?
All right, sir, just have a seat in the audience. We'll take up your case after our morning break. We'll call
If you could just provide evidence, I'll have the intentions of pleading guilty. Again, nothing's been provided on the record. Alright, yeah, sure. What's up?
The jurisdiction question, I don't think you understand jurisdiction.
Oh, I fully understand jurisdiction.
Okay, but the jurisdiction question you're asking about, on the complaint itself is satisfied. If Napa, whatever they accuse you of, right? Whether you did it or not.
Yeah, I can understand if it's like a murder or rape or something.
It's anything.
Any law broken, right?
Any law.
I didn't break any laws. I broke statutes and codes, supposedly, I'm alleged.
Right.
But those don't override the law.
I'm trying to help you. Statutes and codes, which are the same thing,
pretty much
is the law.
It's not the law.
It is the law.
No.
Okay.
That's putting a helmet on your bicycle or putting a light.
They say is a rule of society, whether it's municipal code, whether it's
black people drinking from water, white people.
Laws anymore.
Okay. Cannabis,
which is still currently the law. Okay. So whether it's right or wrong, that's a totally different discussion. I'm just saying what the law is. So I just want to explain the jurisdiction thing. When they say, like, for instance, okay, so for instance, it says people of the state of California versus XYZ. And then they say on or about this date in the county of Napa, state of California, they accuse you of violating whatever, right? By saying in the county of Napa, the state of California, that satisfies the jurisdictional question. Under the law, it satisfies the jurisdictional question. Okay?
I never signed up for any of that. I can understand, like, if I join the military, I sign off my life to them.
Right.
They have jurisdiction.
Right.
I never did that to these guys. These are just men and women trying to collect money from me.
It doesn't matter.
I didn't hurt anyone, and there's no damaged property. So there's corpus delicti.
Jurisdiction.
Done.
Okay, you don't understand the terms you're using.
No, I understand.
Jurisdiction, all that means is the ability for the court to hear this. Okay? So for instance, if this happened in Solano County, this court couldn't hear it. Okay? So all I'm saying is...
Yeah, it happened in Napa.
Right.
Whatever they're alleging me with.
Which means that, now, whether you did it or not, different question, has nothing to do with jurisdiction. Okay? That's what you argue out.
Well, it's because for me to go further in this room, in this office with these people that I don't even know, they need to prove their jurisdiction.
Which they have.
They don't have facts, though. They don't have actual evidence, physical evidence.
Listen.
They have a piece of paper saying I have jurisdiction.
That's all.
That's not physical evidence.
No. Evidence is not jurisdiction, though. Jurisdiction is the allegation that this took place in Napa County. Whether it actually
jurisdiction is an element of these accusations that they're accusing me of, though, right? It's an element,
and
like injury.
And they've satisfied that by saying this took place in Napa.
Just by saying it.
Yeah.
That, like magic.
Right.
No. That's in the real reality. No, that's not how it works. You can't just be like, hey, I have jurisdiction over you. Who are these men and women?
Right.
They say they're my government. Where's the proof?
So I'm assuming you got a ticket, right?
No, they pulled me over and accused me of having cannabis and not listening to an officer.
Right. Okay.
I got pulled over for there was no crime committed.
Okay.
They just pulled me over.
Right, but they pulled you over.
And they don't have jurisdiction either. That's why I didn't roll down my window for him. Just because he has a badge. I've seen people get their house raided by fake police. I don't know who the hell this guy is. I have the right to privacy. I have the right to pursue happiness. You know, what the hell? I'm rolling my window up and I'm getting pissed.
Right.
You know, I'll citizen arrest him.
Right. But we're all subject to the law. Whether the law is a good law or bad.
Common law, reality, hurting somebody, damaging their property, law.
Okay.
Right.
Well,
I mean, don't you agree? If you got pulled over, brake lights out.
Right.
Who's hurt? What happened? And all of a sudden, this cop's trying to search you.
You're
going to protect yourself, right?
I happen to agree with you. I'm trying to tell you what the law
So I'm
is.
standing up for my rights.
Right.
So until we all start helping each other do that, this is going to keep happening. They're going to just keep screwing
But
people over for no crime.
I'm just trying to help you with the question of jurisdiction.
I fully understand what jurisdiction means. That's why I'm asking them, hey, can you provide evidence? And when they point
And the
towards a
evidence-
police statement,
Right.
that's not evidence. There's no physical facts there.
It is the evidence. That is enough. The allegation that this took place in Napa.
That's just your opinion and their opinion. Where's the facts?
You gotta let me finish,
Mhm.
okay? I'm trying, I
I'm
swear
happy
to God.
to let you finish.
I know, but you keep interrupting me. I swear to God, I'm trying to help you, okay? Jurisdiction is, hey, court, can you hear this? If the answer to that is this allegedly took place in this county, then the answer is yes, court, you can hear this. That's jurisdiction. That's all it means. It has nothing to go, it means nothing as far as whether you're guilty or not. It doesn't hurt you or help you. All it means is that this court has the power to hear this matter to then let you fight it or not. Okay? That's all jurisdiction is.
Yeah, well, they're going to have to force me into a plea because I'm not pleading until they can prove their jurisdiction. And that's going to be under threat, duress, and coercion.
It's not jurisdiction, okay? So what I'm saying is you gotta get past the jurisdiction question. They have jurisdiction. They have to prove that you committed the crime or not.
Okay, so
That's totally separate.
I can go say I have jurisdiction. You just go pull someone over.
No, because you're not the state.
Who are these people?
I don't know that.
Just because he has a robe and a nice building, they have jurisdiction?
Right, because they're authorized by the state and we live.
Who's the state?
The state.
So the state pays them, right?
The state
The
pays
state,
them.
then
And
doesn't
we
the
pay
state, but doesn't the state pay the prosecutor too?
You pay taxes?
No, no way.
No?
Why would I pay them? So I'm trying to figure it out. The prosecutor gets paid by the state, the judge gets paid by the state, so the lawyers, the already paid lawyers, so they all work together.
No,
Already, that's not a fair.
They don't work.
Well, I mean, they don't work together, but they all get paid by the same people. So if you help me right now challenge jurisdiction and get it through their head, like, hey, where's the facts? Just the paper is not facts. Come on. Then right there, you'd be looked at. This guy helped him, and he's able to get him out of here. You know?
No, I don't get paid by the state. I'm a private attorney.
Okay, but I'm saying if you are coming into these courtrooms, you have leeway if they like you. You know, if they don't like you, obviously they're just gonna play hardball on you, and they're gonna railroad you all the time. Yeah, I did nothing. I literally got pulled over, harassed. They searched me. They threw me in jail and hunted my truck.
I don't care what happened. I'm just trying to explain and help you with the jurisdiction question. You're not accepting my definition of jurisdiction. I wish you the best.
It's a definition.
Law. But until you realize that, until you accept that jurisdiction, the question that you're bringing up has nothing to do as far as your guilt or innocence, has nothing to do with it, okay? All it has to do is...
Isn't it an element of the accusations though?
No.
Isn't that a...
No, it's not.
It's not.
Jurisdiction is only the power of this particular court to hear a matter. So if this happened in Solano County, this court couldn't hear it. You'd have to go to Solano County. If it happened in Los Angeles County, this court couldn't hear it. You'd have to go down to Los Angeles County. That's all jurisdiction is. So the
jurisdiction's pretty big. I mean, it's like...
Yeah, no, I'm arguing or asking about as far as jurisdiction.
Yeah, I'm not arguing. I'm just asking a question.
Well, arguing meaning positing statements to the court, okay? Saying, look, they have to do this court. They've done that. It's what I'm saying.
Yeah, they said it's on a piece of paper, but there's no facts.
It's in that this took place in Napa. You're not arguing that it didn't take place in Napa.
If they can come up with any physical evidence that the Constitution of California applies to me, I will plead guilty today.
The fact that
That's all they gotta do.
you're present here, whether you were a resident of California, doesn't matter. If you're in our boundaries.
I understand.
It applies.
Yeah, it keeps going in a loop.
Right. So the
Our
fact that you're
conversation.
here- Right, so the fact that you're here.
That's just words though. Where's the physical proof? Like if I shot someone, where's the gun? Where's the glove?
The physical proof that it applies to you is the fact that you're standing here within this state that we call
But
California.
he didn't hurt anybody.
Yeah. And I'm only standing here under threat.
I'm not saying or it did wrong or whether it was even a crime. All I'm saying is the fact that you're here in California, in the county of Napa, okay? And what they're accusing you of, they're saying you did this, whether you did it or not, doesn't matter, because that's later. But they're saying you did this in Napa County. That's all jurisdiction means. Okay? So if you want to fight your case, you gotta get past that.
They have no case if they have no jurisdiction. They have no case. I didn't commit any crime.
Okay. All right. Well, good luck.
All right.
Good luck.
Right, sir, how you?
Like I said before, I'd like to just get this over with today. And I do have the intentions of just pleading guilty today. If, I did ask about jurisdiction, and it has been challenged. I know that she brought up the ticket, but I don't understand how that's actual physical, facts that the jurisdiction applies to me. And, I'm interested in resolving this today, but to be fair, I feel it should be discussed, and dismissed at least with prejudice, unless the prosecution can show any evidence of the statutes and code being applicable without me being a party to it. I said I had the intentions today just to get it over with, because I'm moving to Austin, Texas, and this is silly. I got pulled over and they alleged I had cannabis. I didn't listen to a cop. I don't even know who these men were pulling me over.
Your Honor, one of the local attorneys who's here on another case did try to chat with Mr. Vaught on the break and explain to him what jurisdiction is and what needs to be proven.
Objection. I understand what jurisdiction is.
Well, and I think the defendant still is not understanding how it works, and I'm prepared to submit to the court that he doesn't understand the nature of the proceedings. I just invite the court's attention to Penal Code Section 1368.
Objection. Point of clarification. What is this penal code? I don't speak this legalese language.
Yes, there are different codes.
Yeah. Codes and statutes. It's the same thing, right?
And it's Penal Code Section 1368.
Do you have something I can look at that says this? Because I never went to law school for any of this. And
Well, what the court has to determine right now is if I believe that I should have your matter referred for someone to speak with you to determine whether or not you are competent to understand the proceedings.
Competent.
Correct. It seems as if you understand lots of things. It doesn't appear to me that you understand what is going on in this legal realm. And it may be that you really just need to sit down with an attorney and have that person explain something to you, or I don't know what the order.
yeah, the attorney did talk to me. I don't know who that man was. He doesn't represent me, but from my understanding, I feel this should be dismissed because he says the ticket is jurisdiction. Just because I'm physically here in Napa, that ticket says, hey, this means we have jurisdiction over you. But the only way for me without a victim is if I have agreed. And I just, show me where I agreed to this.
So you're incorrect. So I don't know if you just don't understand the legal terms or you just don't understand things. And I can't really make a determination right now, but I'm going to appoint the public defender. I'm going to try to do step by step. I'm going to appoint an attorney to help you. And then after that attorney speaks with you, then he or she can let the court know what their